हॅलो, टेंभुर्णीकर सर.
हॅलो, गुड मॉर्निंग.
गुड मॉर्निंग सर. आवाज येतोय व्यवस्थित?
व्यवस्थित आहे ना?
येस सर, येस सर.
व्हेरी गुड. येस सर. जाधव सर गुड मॉर्निंग. पाटकर सर गुड मॉर्निंग. चाटुपळे सर गुड मॉर्निंग.
व्हेरी गुड मॉर्निंग.
पंकज सर गुड मॉर्निंग. देशमुख मॅडम गुड मॉर्निंग.
गुड मॉर्निंग सर. गुड मॉर्निंग सर.
गुड मॉर्निंग सर.
Good morning. I hope you can hear me. Good morning. I am Dr. Pankaj Venkatrao Bhange, Associate.
Good morning, Pankaj sir.
Good morning, sir. Good morning. I am Dr. Pankaj Venkatrao Bhange, Associate Professor and HOD of Agadtantra, Ayurved and Vidhi Vedakyam in Dhanantari Ayurved Medical College and Charitable Hospital, Udgir. It is my honor to welcome Chairperson, eminent speakers, and all participants in National Webinar on Ethical and Legal Aspect of Practice of Medicine. There is a unfortunate side news about Dr. Bhure, who is the famous doctor and with the good moral values, who is not with us now. May his soul rest in peace. सर काय धन्वंतरी पूजन आणखीन हे कोण सर I request Dr. Kulkarni sir to for Dhanantari Pujan. I request Dr. Patil sir for condolence of Dr. Bhure sir. Let's pray Lord Dhanantari to give us strength to fight against COVID pandemic. Thank you, Patil sir. Thank you, Kulkarni sir. Thank you, Patil sir. सर तुमचा स्पीच आहे आता हो आता तुम्हीच आहे
Due to technical issue, Dr. K.D. Chavan sir. Honorable eminent speakers, chairpersons of both the sessions, delegates from all over India, I welcome you all on behalf of National Webinar on Ethical and Legal Practice. This is the particular topic we have chosen for this webinar. Nowadays, we all know the importance of rights, responsibilities, and the way we are supposed to be there as a clinician in the society. Both the speakers which have been chosen for this particular seminar are working in this sector on large level. Dr. Vinayak Tembhurnikar, who is National President of National Integrated Medical Association, India. Honorable Sir had worked as President Maharashtra NIMA also, and his genuine approach, knowledge is definitely can't be compared. Dr. Tembhurnikar sir, I welcome you on behalf of our organizing committee. Dr. Abhay Patkar sir, who is also a technically soundproof person and being academic council member of MUHS Nashik, he had rendered many diplomatic issues checked at his level. Dr. Sangita, Deshmukh, Dr. Gajanan Chatuphale ji, all are definitely working at their institutes in a well-to-do manner. The participants are requested to go through this lecture both as academic point of view, as a practice point of view. Just now I had a message from our inaugural guest, Registrar of MUHS Nashik, that he is in traveling and not in range presently. Definitely he will join and extend his best wishes as and when he will be in the range. So once again, I welcome you all. I hope this webinar will definitely enrich your knowledge and ultimately it will be fruitful for the society, which is our ultimate goal. Thank you. Thanks a lot being joining and being participated in this national webinar. Thank you.
Thank you, Dr. Patil sir, for your inspiring speech. Now it's time to start our first session, that is rights and duties of RMP. For this session, I welcome respected Dr. Abhay Patkar sir as a chairperson. He is the member of Academic Council in Maharashtra University of Health Science, Nashik. Also, he is a HOD and professor of Agadtantra department in A.S.S. Ayurved College, Nashik. Welcome, sir. I am glad to announce our first eminent speaker, Dr. Vinayak Tembhurnikar, sir. He is the president of NIMA, India, that is National Integrated Medical Association, India. I request Dr. Tembhurnikar, sir, to deliver the lecture. Sir, I will share your slides.
Thank you, Bhange sir. Friends, initially, I welcome all the dignitaries who are present in this guest room, as well as I welcome all those who have joined this webinar through YouTube. And I thank the organizers who have invited me for this very, very important lecture. Actually, the subject given to me is I'm able to see the slide. And basically, I thank for these beautiful slides, Bhange sir. You have done a lot of work for this, and I thank for that. Friends, the subject given to me is rights and duties of a registered medical practitioner. Basically, I thank the organizers for inviting me. Actually, Dr. Datta Patil, who is a good friend of mine, he has worked in both the council, in the Maharashtra Council of Indian Medicine as well in the CCIM. He is the authority in this subject, even though he has chosen me as a speaker. This means either he want to check my knowledge or so jokes apart, I thank the organizers for this. Friends, let's start with the lecture or what I want to share with you. Actually, this is not a lecture. I want to share many things with you regarding our rights and duties. Rights and duties of RMP, Registered Medical Practitioners. Friends, actually, Registered Medical Practitioner means who is a Registered Medical Practitioner? So there are a lot of concepts and misconceptions regarding the Registered Medical Practitioner. Actually, in central government, in central ministry, the definition of Registered Medical Practitioners goes like this. Registered Medical Practitioner means a person holding a qualification granted by an authority specified or notified under Section 3 of the Indian Medical Degrees Act 1916, 7th of 1916, or specified in the schedules to the IMC Act 1956, 102 of 1956, or registered or eligible for registration in a medical register of a state, mean for the registration of persons practicing the modern scientific system of medicine, excluding the homeopathic system of medicine, or registered in a medical register other than a register for the registration of homeopathic practitioners of a state who, although not falling within the subclause 1 or subclause 2, is declared by the general or special order made by the state government in this behalf as a person practicing the modern scientific system of medicine for the purpose of this act. Friends, actually going through this legal definition of the registered medical practitioner, it clearly says that the doctors registered under 1956 Act are registered medical practitioners. This means we do not stand in this definition actually, but the state act says that we are registered medical practitioners as we are registered under our council. So in this case, RMP means who has the registration issued by the state council or the central council. So friends, now we are registered medical practitioners, but we are fighting and we have made the demand, very strong demand to the central government that the definition of the registered medical practitioner should be changed and it should be the doctors registered under 1956 as well as 1970 Act, which means our act. Next slide, please. Thank you, sir. Next slide, please. Yeah. So, what are the rights of a registered medical practitioner? So, first and foremost, the most important right of a registered medical practitioner is you can choose the patient. What means choosing a patient? So, you can choose a patient and you can deny a patient also. You can say that I'm not going to see this patient. So, this liberty is given to you, given to the registered medical practitioner, that you can refuse the treatment of a patient provided there are many ifs and buts, provided it is not ethical or it is not in an emergency. So friends, but whenever you accept the patient, you have to do all the things necessary for the betterment of the patient. But however, a public hospital has to treat all the patients. The public hospital, wherever many doctors are working, they have to treat all the patients. Next slide, please. So basic right of the basic right of a registered medical practitioner is that he can prefix the word doctor to his name. So after being a registered medical practitioner, Vinayak Tembhurnikar can write his name as Dr. Vinayak Tembhurnikar. So the prefix doctor you can add to your name and the suffix of the list of the recognized degrees. So what are the recognized degrees? The degrees which are authorized by the Central Council of Medicine, you can write on the board. Not unethical degrees or the degrees. Many times it happens that some NGO or some doctor or some university starts a course, but those degrees or those courses are not authenticated by the Central Council of Medicine, and you cannot write those degrees in front of your name on the board, you cannot display these things. For example, CCH and CGO. You cannot write these degrees on your board authentically. CC, and you cannot write that I am a child specialist or as a gynecologist. You can write these, cannot write, as these degrees are not authenticated, or these are not allowed to display on the boards. So this is the right of the registered medical practitioner. Secondly, can practice medicine. So practice medicine means what medicine? It all depends on the state laws. For example, in Maharashtra, you can practice medicine, Ayurvedic medicine, as well as allopathic medicine, modern scientific system of medicine also, as the state law allows us. In many states, with like Maharashtra, Uttar Pradesh, Haryana, many 14 states, they have allowed our doctors, our graduates to practice modern scientific system of medicine. And according to these state law, you can practice medicine, allopathic as well as Ayurvedic also. Can hold the government medical appointments also. In many jobs, you can accept those jobs also. You can give medicines. You can give medicines means you can give self-prepared medicines also, and you can prescribe the medicines also, including dangerous drugs or scheduled drugs or poisonous drugs, according to the laws. According to which they permit us to use or prescribe some medicines. It all depends on the laws of the state government as well as the central government. Can perform surgeries also. Basically, this is a very big issue nowadays we are facing. The government has published a gazette regarding, central government has published a gazette regarding our doctors, surgeons, Shalya, Shalakya Tantra doctors, postgraduates. They can perform 58 types of surgeries, and they have authentically allowed to do this, and even president's assent is also for this gazette. But many of the organizations who are doing their giving their services in the modern doctors, they have raised objection regarding this. They have gone to the court of law, and as you all know, we are also fighting this court in this case in the Supreme Court of India, and we are NEMA is also one of the party in that, and we are fighting for the rights of our people. So now in fact, this is a practice since many days, many years. We are practicing and performing, our postgraduates were performing many surgeries, but now this has been authenticated. So basically, we can hold government medical appointments also. We can prescribe drugs also. We can perform surgeries also. Next slide, please.
Yes, sir, I'm doing.
Basically, in the rights, you can give medicines also. We can get remuneration or cost of the treatment for the patient, from the patient. So you can demand for your remuneration, or you can, this is your right. So it is not necessary that you can, you should do charity all the times. You can demand your and prescribe or have drugs. This was done. You can government medical appointments. You can perform surgery. Can remove the organs for transplantation. Organ transplantation, you can remove the organs from a dead body as well as from a live body also. You can administer anesthesia as per the laws and the permission granted for our doctors. You can perform post-mortem also. You can perform post-mortem, and you can issue medical certificates, all sorts of medical certificates, including death certificate, birth certificate, fitness certificate, and all sorts of certificates you can give, and the medical legal reports also. In the court of law, you can give an expert opinion. If you are called by the court for the expert opinion, you can give the expert opinion in the court of law. Next slide, please. Other than the opinion in the court of law, you can work as a medical advisor in schools, colleges, and industries also. Another thing is that about the Red Cross sign. Friends, according to the Geneva Convention, we cannot use the Red Cross for the doctors. Only army doctors and Red Cross Society can use the Red Cross, but still it is a practice and all are using that, but ethically it is not allowed. So the duties of the RMP, the right of RMPs is over now, and what are the duties? So the first and foremost duty of a registered medical practitioner is to report the births, deaths, infectious diseases, cases of food poisoning, etc., to the authority. You should, as per your right, or the death and births in which you have basically checked, or you have said that this person is dead, you can give the birth certificate, death certificates, infectious disease certificate, and cases of the what to call as food poisoning, etc. And you have to inform the police the all cases of medical legal importance, the medical legal cases, the cases of crime, the cases of suicide, homicide, accidents, etc. You have to inform to the police, and this is the first. This is a very, very, very important duty of a registered medical practitioner. If you fail to do this duty, you can be charged for that. So this is a very important duty the registered medical practitioners are supposed to do, and you have to respond during the war and the national emergencies or calamities. If a situation of war or war against any infection, just like corona pandemic, when the government asks you to render your services to the government towards the calamity, towards the people of India, you have to respond the government, and you have to give your services to the public. And in the duties while treating a patient, RMP should use all his knowledge, experience, and skill for the betterment of the patient. You should not give any guarantee of recovery to the patient, but should be available for the patient once you accept to treat the patient. You should use the equipments and instruments. Those instruments and equipments used should be clean and sterile also. You should dispense the useful medicines. If you are dispensing, should dispense the useful medicines. And if you are prescribing, you have to prescribe a good in the good handwriting, and it should be a reliable, readable handwriting. Otherwise, what happens? The handwriting of a doctor, nobody can read it except the chemist. And the chemist, you must be knowing the very famous joke. A young doctor falls in love with a girl who is a non-medico. He writes a love letter to that girl, but the girl could not read it. At last, she has to rush to the chemist nearby and read it from him. So this should not happen. Your prescription should be very neatly written with a good handwriting, and the dosage should be clearly mentioned on the prescription. Clearly mentioned, and the do's and don'ts, patya patta, should be told to the patient properly and in the convincing matter. As I said, you have to report the births, deaths, infectious diseases to the authority, to inform to the MLCs, to the police, all accidents, crimes, suicides, homicides, poisoning, etc. And next slide, please. There are some fundamental duties of a registered medical practitioner. This is very important, friends. You have to maintain a good character. character in many ways. You have to regarding the patients of opposite sex. You have to be particular. You have to be very humble. You have to be very careful while handling these the patients of opposite sex. There are some ethics whenever you are checking or treating a lady patient. For male doctors, you are treating a or checking a lady patient. There must be some relative, or your if the lady don't have any relative with her, you have to uh, call your assistant or any staff of your dispensary or clinic or hospital while you are checking this. So this character or many other ways, the financial and the social character must be also very humble and very good. Good character should be maintained by a doctor. You have to treat the patient using maximum knowledge. You have to use all the knowledge you have with you for the treating the patient. You should take utmost care of the patient while treating and till the patient is with you. And the skill, there are many things which are not taught in the books or in the colleges. The skill is developed by you, and this at most your best skills you must use for the betterment of the patient. Next slide, please. A day comes or a time comes when you have to stop the treatment. So when you have to stop the treatment, there are many circumstances when you have to stop the patient. The best and the which gives you a sigh of relief or you become happy when the you have to stop the treatment as the patient becomes all right. This is a very great experience. The patient is now all right and I have stopped the treatment. The second, when a patient refuses the treatment. If a patient says, no, I don't want to take medicine from you, I don't want a treatment from you, then if he refuses, you have to stop the treatment. If the patient is non-cooperative, if you are saying, if you are, while treating the patient, you have given some medicine and you have said that this medicine should be taken twice a day, thrice a day, and you have to do this, you have to avoid these things, and the patient is non-cooperative, he's not taking medicine, he is not taking proper care, so you can stop the treatment. If the patient does not give consent for a treatment, many times this happens. When an alcoholic patient comes, the relatives of the patient come and they say that he is consuming a lot of alcohol. He has become a mess for the family, and he's fighting with the relatives and family members. So please start the treatment. But he has not given the consent for the treatment. So you should stop treating such patients. If a patient consults another doctor without your knowledge, if he is taking some parallel medicine, some parallel advice without your knowledge, you can stop the treatment. If he insists on poisonous drugs or the drugs which are banned or which are not helpful for his well-being or for his health, you can stop the treatment. Many times it happens. Many people are taking regularly some sort of narcotics or some sleeping pills or any other treatment, steroids, unethically they are taking. And if they insist, doctor, please prescribe this drug to me, give a prescription, as the chemist is not allowing to me. So you should not do that. You can stop the treatment at that moment only. This actually he does not pay his fees, but you cannot what to call as stop or deny the treatment. This is a point of discussion, but anyway, it's up to you. You can stop the treatment if he is not paying. And the last but not the least, if the patient dies, you have to stop the treatment, as if he dies, then to whom you are going to treat. So in these circumstances, the treatment can be stopped. Next slide, please. In other duties, not to involve in unethical practice or professional misconduct. Nowadays, there are many unethical practices are being done in the society in many fields. It is said that many times doctors or medical field is also involved in such things. So, we should not involve in the unethical or professional misconducts. In that, there are many sorts of unethical practices. You should not advertise your profession in newspapers, in the newspapers, or print some posters or banners or distribution of pamphlets, etc. Or many times when you are wandering in your city, in a vehicle, you see many auto rickshaws, and behind those auto rickshaws, many doctors have advertised their specialties or their skills. This is not, in fact, this is unethical. You should not involve in these things. Other than that, many times professional tie-ups with the pharma companies or chemists on percentage basis. This is also said that many doctors or many professional, our brothers are doing such type of unethical practices, that they tie up with some pharma companies with some percentage or some gifts, and some chemist also. So you should not involve in this type of, this is unethical practice, and unethical practices are not allowed. Another thing is that you should not start your own medical stores and prescribe unwanted medicine or substandard medicine. Many times a doctor starts his own medical stores in front of, or in the campus only. But this is basically, law cannot prohibit, but this is unethical, and you should not involve in such things. Uh, Another thing of unethical practice is that you cannot promote, you should not promote or advertise the treatment in front of a mob of people. You are in a playground, or in a ground, or in a premises of some hotel. You are gathering some people and advertising your expertise. This is actually unethical. Or to give or accept referral money, or money for a referral, it is also unethical. So please admit your patient in my hospital. You will get this percentage uh, of the bill of the patient. This is unethical, totally unethical, and you should not. Basically, it is punishable also. So please don't involve in such activities. Another thing is that you have to maintain professional secrecy. There are many things in the treatment part that the professional secrecy should be maintained. His what to call as his shortfalls, his lacunas, and his social and this status, and his bad habits, and these things should not be exposed, should not be breach of this thing. Secrecy should not be done at any cost, and patient can claim amount for this breach. Remember, he can go to court of law and he can claim the amount from you. The investigations and treatment to be done only after proper consent only. If the patient is not ready, and if he smells something that this type of investigation is not needed for me, or it is unwanted, so he doesn't give the consent, so he should not go for the treatment or investigation unless and until the proper consent is given by the patient. You should always encourage the second opinion. Second opinion, in many cases, or many things, many circumstances, you can have a second opinion that can be discussed later. Be careful in the society. Be careful in the, selecting the patient, and during investigations, diagnosis and treatment also. You should be careful while selecting the patient, and during investigations, diagnosis and treatment. Next slide, please. In other duties, proper precautions should be taken to avoid spread of infections. This is very, very important. The infectious patient should be kept separately or they should be isolated to avoid the spread of the infection. Nowadays, it is very important. It has become very important in a pandemic situation like Corona, as it spreads like anything with a supersonic jet speed. So this is very, very important that the proper precaution should be taken to avoid or to stop or to minimize the spread of the infection, and should use standard drugs, instruments, and procedures. This is actually, I have told previously also, only standard medicine, standard procedures, standard instruments, and procedures should be done. Substandard is not allowed. No compromise while treating the patient should be done for the standard of any drug or instrument or procedure. Medical record. You should maintain a proper medical record, as it is very, 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 very important while seeing the medical legal cases. As you all know, many a times, many doctors have escaped from many cases due to proper recording only. You have to keep proper records, and as per law, you have to keep record as per the requirements from 3 years to 7 years. You have to keep these records, and a proper record should be maintained and should be preserved for 3 to 7 years as per the requirement of the cases. The very important part is that for the gynecologists and general practitioners and the radiologists who are practicing in the society, that you should never go for sex determination in a case of a pregnant lady. No sex determination should be done, as it is a punishable and a very, very grave offense. You should not go for that. Even though yesterday only Indurikar Maharaj has escaped from the case which was lodged. Basically, he is not a medical practitioner, but in a kirtan, or what you call as, he has said that for male what you call as for male this thing, boy, if you want a boy, it should be done like this, and many people or social organizations had gone in the court of law, and he has escaped in this case, but there is no escape for doctors. So you should not go. It is criminal also, and it is non-ethical also. So please don't go for sex determination, friends. Next slide, please. Now, regarding the second opinion. Previously, in last slide, it was stated that you should always go for a second opinion, encourage the second opinion. So when should we take a second opinion? There are many circumstances in which you can have a second opinion. The first is when the patient requests. If a patient requests, doctor, you are doing a great job, you are doing very good treatment for me, but I think, or my relatives think, my family members think that a second opinion should be taken, then if a patient requests, we always encourage for a second opinion. Another thing is that when a patient does not respond to the treatment, you are doing everything for the patient, for the recovery of the patient, and unfortunately the patient does not respond to the treatment, then you have to go and you have to apply the mind of other specialist also, and you have to go for the second opinion. When a patient cannot be diagnosed, this is also very important. Patient has come with some vague symptoms and very complicated symptoms, and if the patient is not diagnosed properly, as there are n number of these symptoms, and those are very complicated one, so you should go for a second opinion if he is not diagnosed. When the patient becomes serious, means he is not responding to the treatment, then you have to go for a second opinion. Any operation in the emergency, when operation is in emergency, you have to perform a surgery in emergency. we don't know what the patient history is not known to you. The patient is not familiar with you. He has come with some emergency this thing. Uh, in some emergency has come to the operation, you have to perform a surgery and you have to take second opinion for that patient also. Next slide, please. Any operation that can interfere with reproductive capacity. In this case also, you have to go for a second opinion. Any operation that can interfere with the reproductive system of the patient, you have to go for the second opinion. In a homicidal injury, you have to go for the second opinion. In a homicidal poisoning, you have to go for the second opinion. In a criminal abortions, you have to go for the second opinion. And homicidal burns, if the burns are, the patient comes with burns, homicidal, the patient tries to make an end of his or her life. In that case, he or she tries to burn herself or himself, and you have to, in that case, a second opinion can be taken. You have to encourage for that. Next slide, please. Any operation that is dangerous to the life. This also needs a second opinion. While you open for surgery, you can come across many emergencies or many problems you can come across, and in that case, the second opinion must be taken. In mutilating surgery, in MTP beyond 12 weeks, in MTPs beyond 12 weeks, you have to take second opinion, or you should encourage for the second opinion. Declaring a person as insane or declaring a person as dead if organ transplantation is to be done from his dead body. If a person is dead and a person is dead after his death, the organ transplantation is to be done on his dead body, then the second opinion should be taken. This is very, very important. Next slide, please. Vice versa, when you are removing organs from a living person for a living person for organ transplantation for another patient. In your case also, second opinion should be taken. When complications of treatment not informed to the patient. If a case comes and if you are performing surgeries in that or any treatment part you are doing that, the complications that can arise in that particular case are not informed to the patient, then you have to go for a second opinion also, as the knowledge or the expertise of that particular doctor, of that particular specialist are very, very, very important for the life saving of that patient, particular patient. The treatment in emergency without any consent also needs a second opinion. Postmortem on dead body of a newly married girl. This is a very important. If a newly married girl dies, the postmortem is done. In that case, many questions arise, and these questions are very, very important on legal front, and so that you have to take a second opinion in this case. Next slide, please. So, friends, these are in gross the duties and the rights of the registered medical practitioner, and the ethics, the ethical practice is very important. And I request and I with folded hands to all of you that don't go beyond our limits. The limits are finalized by the government. The government is with us. The government is doing many things, many positive things for the doctors of Indian system of medicine, and it is our first and foremost duty that we should do ethical practice. We should thank the government. We should be obliged with the government. The government is doing n number of things. As you all know, National Integrated Medical Association (NIMA) is fighting for integration since last 72, 73 years. In 1948, NIMA was established, and since that period, we are fighting for integration. And the present government has taken many steps towards the integration, and there are many more steps to come. In future, the medical colleges from India will be entitled to run integrated courses in the country, and the first step of in that direction has taken by the government. We should be thankful and obliged to the government also, because first time such government has come, and we should we are bound to do our duties, which is bound to work as per our rights and in our capacity only. So, friends, this is the this is what I was supposed to call. So, with this, I conclude my talk with you. And friends, I thank Sri Dhanvantari Medical College, Ayurvedic Medical College and Hospital, and the organizers of this webinar, and those who have arranged, taken part actively, and those who have listened my speech, or I don't call it as a speech, my what you call as views regarding this. So thanks for the patient hearing, and thanks for giving me this opportunity. Thank you, everybody.
Thank you, sir, for such a informative speech. Sir, there is a one question. May I ask?
Yeah, definitely.
1 minute, sir. There is a question in a chat box from the participant.
Yeah.
Is
Please.
there any standard format for keeping record on OPD level?
Definitely, there is a standard format for register, for the certificates, for the prescriptions, everything. The standard format is there, and in many books it has been given that what sort of standard certificates or register should be kept. The formats are there. Even prescription formats are also Maharashtra government has formed a committee regarding I think in 2013-14 a committee was formed regarding the standard prescription format also, that has been also published by government.
Definitely, as said Dr. Tembhurnikar sir, Dr. Pankaj sir, those who are in need of those typical documents regarding ideal rather standard format of prescription, rather consent letter, which is supposed to be from the patient's relatives, rather patients, each and everything is with us. You can share those documents on the chat box also. I will provide you within short of time. Thank you, Dr. Tembhurnikar sir, for the best speech. Is there anything questions which are expected from others, Dr. Bhange sir?
No, sir.
Okay. I request Dr. Patkar sir to please go through his chairperson's speech, and I hope both the eminent speaker and chairperson will enrich and rather enlighten the typical legal and ethical practice in the day-to-day life. Dr. Patkar sir, please go through your speech.
Thank you, sir. At the outset, I extend my sincere thanks to the Dhanvantari Medical College for organizing us a nice webinar on this most important issue. All of you know that there are many aspects of the medical practice. And in today's webinar, the organizer has covered two aspects, that is legal aspects and ethical aspects. Both the eminent speakers are very good. They maximum cover the legal aspects of the medical practice. And as a teacher of this subject, I can understand that it's a very big topic and subject for 1 hour lectures. Dr. Vinayak ji has did his best to summarize each and every points and everything in his 1 hour lectures. I congratulate him and thanks him for his nice presentation. He's a role model for practitioners as he is a leader of NIMA, and basically I am also associated with the NIMA. It's a very brief history and long history for the NIMA. Just is an organization from 70 years in fighting for the rights of the doctors. Friends, this is just two sides of the coins, the rights and the duties. You can't at a time see the only one side. Always you think about the both the sides, rights and the duties. And nowadays people are more concerned about the rights and they are forgetting the duties. And I think this webinar will compel them to introspect whether they are performing their duties for the society, for the patient, for the doctors, as desired by the lawmakers, or they are running just on the financial aspects and the other aspects. So this is a topic open for the introspection of every doctors. And one of the most important thing for the rights is a right to practice the allopathy, for which all credit goes to the NIMA and the NIMA authorities. Though it is a sub judice matter, all of you know that as per the Constitution of India, education and health, these two fields of the medical sciences are covered by different schedules. Education is totally covered by the central government, and health is covered by the central and the state regulations. So the condition of the health services in Maharashtra is different, in the Gujarat is different, because the state law permits states to make some changes in their state laws. And we will see, as this is a national webinar for the Ayurveda doctors, especially Ayush doctors. So the conditions of Delhi, Gujarat, Bihar, for education purpose, it is regulated by the council and the central government. But for the health practice services, these state governments are responsible. And I'm proud to say that Maharashtra government did this well for its common public and welfare of the patients. And when the 1956 Act was passed for the Indian Medical Council, it was the first state in the country who passed MMP Act 1961, just 60 years back. And the provisions made at that time while drafting the Act are now, we are using them, that provisions as the fruits of the medical practices. And so the end of that is a right to practice the allopathy. I think this is the only state in Maharashtra who clearly offered a privilege or a right for the general practitioner or the Ayush practitioners to practice allopathy or modern medicines. But friends, there are one line under this act that the privilege is given up to the extent of the knowledge they received in that system. And that line is has to be explained or clarified by the what it actually means. Many doctors are having different opinion on the contents of this line, but it's as a legal issue. I'm not going in detail, but what exactly means the extent of the knowledge the doctor received in that particular system of medicine is a point for legal elaboration as well as its practical elaboration or academic elaboration in the form of syllabus, practicals, and practices. So I think it's a big issue before university and the academicians to frame some guidelines for this perfect line. All of you know there's these all privilege or rights to practice the modern medicine is challenged by the IMA Pune. And there are two petitions, 7846 and 7847, pending in the Bombay High Courts. Both the petitions are admitted by the court. It means it's having some substance. I am having some different opinion, though I am also associated with the NIMA. But I will give the only one example, as there are many religions in our country. And every religion is having its own principle, concepts, its religious spaces, methods, even dress codes, sports, everything differs. And the same principle is applicable, you can apply to the pathies also. There are many pathies in the world, in the country, in our India also, there are about 20 to 21 pathies, people are practicing. And so each and every pathy can be identified by its basic principles, fundamentals, and its applications. So there is no question that the Ayurveda is a different and ancient Indian system of medicines. Too old than the modern medicine. It is acceptable. Charak Sushruta are also worshipped by the Western doctors also. This is a fact. But nowadays we are losing our identity due to this integration. So this is my opinion that now time comes. Time comes, and this is the duty of the teachers of Agadtantra to think on this specific issue, that in the glory of this technology and the era of politicizations and the development, we have to first preserve our values, preserve our principles, preserve our practices, so that the next generation will know which principles and which practices are followed and carried out by the expert of the Ayurveda in the India before the independence. And so this is a big task before the academicians. I don't expect this all things from the practitioners, because their role in the health services is quite different. So as an academician, I personally think that the teachers of these subjects should go details by this angle and think how this thing should be protected. Now it's a matter is subjudice. It's not good to talk more on this point, but this is my personal opinion. 2 to 3 years. So before 2025, that amendment in that section 25 of the MMPR 61, whether it is a constitutional or not, that will be answered by the High Court. Might possible that decision will be challenged by the government or the other people in Supreme Court also, and ultimately in 2026 or 2027, you will having a clear judgment whether an Ayurvedic person is having a right to practice allopathic medicine or not, or if yes, up to which extent. Because there are differences. Lot of differences are there between college, curriculum, syllabus, students, their need marks, their teachers salary, everything differs. So even a layman can't expect that the rights of the both MBBS and BMS doctors should be same. If we are asking for the 100% same rights, then we are misleading the present facts. So there must be some differences. So how these differences can be put, how this can be framed, is a matter of regulatory authorities to frame the regulations in futures. But this is my personal opinion that up to 2026 or 27, the things will be clear, and later on we will find out the different Ayurvedic academic picture in our country. When Vinayak ji and I learned there are only 19 colleges in the Maharashtra, and now the number has grown up to the 85. Why this number has grown, everybody knows. What is the actual standards of the teaching and the practices? Many students who pass from these colleges are having a big hospitals or a number of OPD patients they see daily, or their IPD patients is quite large than prescribed for research colleges. This is the conditions of colleges. So all these doctors or graduates from Ayush Pathy, they develop themselves. They learn everything, and this is a fact, or you can say the principle behind their today's success. So this is a very big subject. I again congratulate Dr. Vinayak ji for giving a very nice, a very short, but covering each and every aspects of the medical duties and rights topic. And I wish a great success to this webinar. Thank you.
Thank you, sir, for such an informative speech, and thank you for your time, sir. We are honored to have you, sir. Thank you, sir. Dr. Tembhurnikar, sir, we have some questions for you from participant. May I ask?
Yeah.
Your time,
Yeah,
sir.
yeah, definitely.
So you have the questions from participants to put on the chat box.
Yes. Can BMS MD Kai Chikitsa open his own ICU center on his own registration number in Maharashtra state?
Yes, definitely.
Okay, sir.
There are many ICU centers which are run by our MD Kai Chikitsa people in Maharashtra, and they are running it very, very successfully also.
Okay, sir. And there is another question. How and where can we report births and deaths?
To the authority, local authority.
Yes, of course. Yes, sir.
Within 72 hours.
Sir, there is
Yeah,
one
within
more
72
question.
hours.
Can MD Rog Nidan can open his own pathology setup?
Actually, this matter is not that clear. Basically, in many states other than Maharashtra, our people have opened many pathological laboratories. But in Maharashtra, I could not see any pathology laboratory run by our people.
Okay, sir. Thank you, sir.
But in many states, in Haryana and Punjab, many of our doctors have started their own laboratories.
Okay, sir. Right, sir.
Hello, I will add one more thing. Our peoples, on
Yeah.
the basis of their experience, their knowledge, their hard work, they are doing many things. And whether they are competent or not, I am sure they are competent. They are having enough
Yes,
number of
definitely.
applicants also. But the basic question is whether they legalize, whether they are authorized or to practice the laboratory. That is the question.
That is the
That is
main,
the main
question.
question.
And it is not clear. It is not clear.
Today clear, so you have to go.
Sir, Tembhurnikar sir, one more question is there.
Yeah.
How can we know which state practitioners can practice both allopathy and Ayurvedic medicine? One of the delegate had given this question for you to go through his clearing doubts.
I could not get your question. Please repeat.
I will answer.
Yeah,
How can
Patkar
we
sir.
know which state practitioners can practice both allopathy and Ayurved medicine, and in which states only Ayurved graduates are entitled to be the Ayurved practitioners?
I will answer these questions.
Yeah,
The
Dr. Patkar.
practitioner enrolled in that particular state has to visit their website of their state councils. If there is any provision in state act or state council regulation, maybe they can practice in that state. So there are 2 or 3 ways to know whether they under a particular state the practitioner of Ayush is authorized or not. So he can ask a question to the Secretary of State Council. He can put a question under RTI, or he can refer the regulations or act of that particular state. As there are many states, so we can't prepare a list that these states are going to permit, or this in these states there is no provisions.
But roughly there are 14 states, 13, 14 states where our people are practicing allopathy, modern system of medicine through act amendments or in, GOs or GRs
Written
or notifications. Your mic is muted, Dr. Patil. Your mic is muted.
Sir, one more question is there. Why there is discrimination between MBBS and BAMS graduates regarding practice, rather social and political equality? And he had also, rather she had also, Snehal is there, she had also stated that why we are struggling for all these things.
There are n number of reasons behind this because what you call it in Marathi, she said that आपण सवतीची लेकरं आहोत, and the government राजाश्रय नहीं है ये बोलते हैं. गवर्नमेंट आज तक की जो गवर्नमेंट थे वो इतने हमारे लिए पॉजिटिव नहीं थे. There are n number of things. Our people don't wanted to fight for their, in fact, they were not willing at all to fight for their rights and for their, this are in fact not fulfilling this thing, utility हमारी जो है वो गवर्नमेंट को दिखा नहीं पाए आज तक. There are n number of things. Other side is that the association, IMA is the only association, and in Ayurveda we are n number of associations. They are not united. We are not able to create pressure on the government also. अगर हम लोग सब एक साथ जाते हैं तो प्रेशर बनता है, लेकिन हर एक जिले में अलग ऑर्गेनाइजेशन है. There are a number of reasons behind this. The IMA lobby is very strong politically and financially also. So these are the things why we are not able to get proper this thing rights for our people. These are the things.
Definitely, sir. Just as you said, together we can, together we will. There should not be the barrier of different means organizations amongst our graduates, which is creating hurdle. It should be overcome somehow. Definitely, as a leader like you, will take initiative to get this hurdle clear. One more question is there. Means she had clearly stated that there should be law for MBBS graduates who are prescribing Ayurvedic medicines. So, regarding this particular question, what should be your opinion, sir?
Basically, we are fighting for integration. इंटीग्रेशन का मतलब ये नहीं है कि ओनली आयुर्वेदिक डॉक्टर्स कैन प्रैक्टिस एलोपैथी. So integration means all doctors should learn everything and they should practice each and every pathy. But in the present scenario, MBBS doctors are not competent to prescribe Ayurvedic medicine, so they should not write at the particular moment. Vice versa, our syllabus is competent. We have been taught all modern subjects in our syllabus in the graduation as well as post graduation level. So our right is secured, our right is justified with the syllabus, but they are writing our medicine and it is not justified at all.
I want to ask one more question from Mittal Gala to both chairperson and eminent speaker. Non-Ayurvedic practice persons, just like what we can quote those people as Jhola Chap doctor who are residing at the outskirts of the cities, and they are giving that particular Ayurvedic medicine, and whether there is any law to bar those people. Otherwise, due to these Jhola Chap doctors, technically, legally, and educationally, graduates are being blamed by the various counterparts, including modern medicine.
I will answer the question. As all of you know that in Charak Sangita, the 3 types of Vaidyas are described. What it means, this problem or this samasya, question, is from the 2000 BC year from the Charak era. And up to this date, it is not totally eradicated, not totally controlled. So there are the problems of the society. Somewhere there is a provision in both the Amendment Act 61 and other laws of the state, and the authorities which are responsible to control this mushroom growth or the practices by the third persons. This comes under the rights of the councils. So if anyone write to the council with a concrete evidences and the proofs, councils are taking actions on the such doctors and such issues. There are many 4 to 5 examples in the last year. They are reported in newspaper also. One is, still remember, one is from Kolhapur, another is from Chikli. And some doctors, those find out that such persons are practicing medicines without the registration and without authorization. They make the complaint to the council, and council comes in the action mode and they actually take the actions. So the important thing is someone should approach to the authority that such and such person is doing the unethical practice or illegal practice in that particular area, so that one can initiate the legal action against them. This is the only practical solution.
Basically, council is with us, both Central Council and Indian MCIM is with us. Dr. Patil is member of both the councils. Actually, he can play a main role, key role in this problem. Basically, the laws are not that stringent. If anybody is caught, if anybody, Jhola Chap doctor is caught by the, we report, in fact, in many cities or towns, our NEMA branches have selected, have gone through this type of doctors, and they have given a list to the authority, to the committee, which is working in all these districts under the chairmanship of the district collector. We have given the names and the addresses of such doctors also. But the laws are not stringent. The punishment is not that solid. Punishment cannot give that. That's why these things happen. As you stated, Dr. Patkar sir stated, the famous man from what you call as quack from Kolhapur is being what you call worshipped by the this public also and by the politicians also. these type of these thing blessings are given by the politicians and the public, and that's why they are doing it on a large scale and without any fear. So the laws must be stringent, the laws must be strong. If anybody is dealing with the lives, he is playing with the lives of the people of India, a harsh and very, very what was called a strong punishment should be there in the law. The such type of laws should come in action, and this will be the answer, a proper answer for this.
One more question is there, sir. Means technical and legal issues regarding telemedicine. Hello.
What's the question?
Sir, technical and legal issues are regarding
Proper question.
telemedicine, sir. Telemedicine. Authenticity, rather
Could not
technical
hear
and
you properly.
legal issues related with telemedicine.
Okay, I will answer. Regulation controlling the telemedicine passed by the central government by using powers under the Epidemic Act. The central government comes in the function and they pass the telemedicine regulation 2020. They are available on the Government of India websites and they are legally framed. They legalize the telemedicine for this pandemic. Whether it will be continued for the rest of the years or not, that is
It is not clear.
it is not clear. But presently, for this pandemic time, telemedicine for the all pathies is a legalized. Even we can, Ayurvedic doctor also can treat their patients by using the telemedicine facility. Nothing.
And it is clearly given on the website. All the details regarding these guidelines are on the website also.
Patil sir. Hello.
Sir, mic is muted.
Sir.
Are you listening to me?
Sir.
We are discussing here on
When will the Agadtantra graduates be permitted to be appointed in FSL or even to conduct autopsies?
There are two questions mixed. The BMS doctors authorized to work under the FSL. Actually, no MBBS doctor is directly appointed in under the FSL. Okay, because FSL comes under the Home Department, and there are many courses under the forensic science. One course is in BSc forensic science. After completing that course, these people are working as a pharmacist or bioanalyzer in the FSL. So FSL is a laboratory work, analytical work. It is not related to the diagnosis and treatment of the medical science. So there is no such provision laboratory to appoint or a doctor directly under the FSL. There is no question comes for the appointment of a BMS doctor. And the second question was, can you repeat the second question?
There are disturbances, could not hear you all properly.
And for post-mortem or autopsy, BMS doctors are authorized. Many doctors are doing the autopsies in Maharashtra, so there is no question.
Sir, one more question is there, sir. Means what had happened, rather what is happening, whether a Kaichikisa graduate, if he is giving physician's opinion during surgery, then why rather in particular areas it is not considered as a physician's opinion, rather fitness certificate?
According to law, we are allowed, and we should raise this our voice, and we are allowed to give the fitness certificate for the surgery. Our voice should be raised. We are competent enough.
One more question is there. Somehow we have got permission for Shalya and Shalakya. What about other subjects, particularly means pediatric, gynec branch, and even if Kaichikisa, we are supposed to get benefits, rather increase the rights of our graduates and postgraduate students.
Yes, this is on the agenda of NEMA, and we are fighting for this. This is in our demand list also, and definitely all the expertise of our postgraduates, they are entitled to get their rights, and we are fighting for that. And definitely, I'm sure, definitely we'll get the rights of our postgraduate doctors in the particular subjects.
Sir, one remote practitioner from remote area has asked a question that what about Bombay Nursing Act registration and the provisions there in the biomedical waste, whether both are applicable to the clinics, or is there any other mandatory thing in which these two are applicable for?
Bombay Nursing Home Act is applicable for the nursing homes only, not for GPs or not for the
They are
consulting
not
group.
covered.
And biomedical waste is applicable for each and every doctor. Muted. You are muted.
What had happened there in remote areas, rather particular areas, sir, the local authorities, those there in the public health department, or even if the municipal corporation, both are compelling the graduates, our graduates, those who are running a clinic only, there is no any IPD, and yet they are compelling the practitioners to register themselves either in the Bombay Nursing Home Act, and even if they are in the Biomedical Waste Act. So these are the things which are means harmful to the graduates' rights.
Basically, as I said, Biomedical Waste Act is applicable for each and every doctor. But in the if a doctor is running a clinic only and he is forced to register under the Bombay Nursing Home Act, he can contact the authority, or in a simple way, they can contact the NEMA branch. We will fight for them. No issues.
Thank you once again. There are many more questions which our enthusiastic participants have raised, but definitely we have tried to clarify their particular questions, rather queries, with the help of our honorable eminent speaker, National President of Indian Medicine, Dr. Vinayak Tembhurnikar sir, and even Chairperson and Academic Council member, Dr. Abhay Patkar sir had enlightened and enriched our knowledge. Thank you once again, both of you, on behalf of our institution. And for a short call, rather short time request, both of you have made yourself available for our national webinar. We are definitely highly obliged for your genuine and creative, constructive approach and attitude which you have shown, rather the means faith which you have shown in our institution. On behalf of institution, I myself and our organizing team, Dr. Pankaj Bhange and Dr. Gadekar, both the faculties of our Agadtantra department, once again I thank you, both of you. Over to you, Dr. Pankaj Bhange.
Thank you, sir. Thank you, Dr. Tembhurnikar, sir. Thank you, Dr. Patkar, sir. Now it's time to start second session. That is a professional misconduct and professional negligence of practice of medicine. I welcome respected Dr. Sangita Deshmukh Madam as a chairperson of this session. She is a faculty member of Ayurved in Maharashtra University of Health Science, Nashik, HUD and professor of Agadtantra department in late B.V. Kale, Manjara Ayurved College, Latur. Welcome, madam. I'm happy to announce our second eminent speaker, Dr. Gajanan Chatuphale. He is assistant professor in department Agadtantra at Govt Ayurved College, Vadodara, Gujarat. Sir, I will share your slide. Just give me a few minutes.
Okay.
I'll just wait few minutes, guys, due to the technical difficulties. Sir, can you see the slide?
Yes, I can see.
Okay,
Please
sir.
make it to the full screen.
Sir, please start the lecture.
Good afternoon, everyone. Firstly, I would like to congratulate Honorable Tembhurnikar sir for such a wonderful lecture. I would like to thank Patkar sir and Tembhurnikar sir. I feel immensely honored to share a meeting with you all. You are senior to me. Honorable Patil sir, Patkar sir, very much for inviting me for this webinar. Topic of my webinar is professional misconduct and professional negligence in medical practice. First of all, I would like to introduce myself. Myself, Dr. Gajanan Chatuphale. Basically, I am from Nanded, Maharashtra. I have completed MD, postgraduate diploma in emergency medical services, and diploma in yoga and Ayurved from Pune. I am working as an assistant professor in Department of Agadtantra in Government Ayurved College, Vadodara since last 5 years. Next slide, please. Good afternoon, members. Honorable Dattatray Patil sir, Principal and Organizing Chairperson, Dhanvantari Ayurved Medical College, Ujgir. Honorable Chairpersons of this session, Honorable Dr. Sangita Deshmukh ma'am, Member of Ayurved Faculty, Nashik, MUHS Nashik, and HOD and Professor, Ayurved College, Latur. Dr. Pankaj Bhange sir, HOD and Reader, Department of Agadtantra, Ujgir College, and Dr. Chandrahas Gadekar sir. Good afternoon, everyone. Next slide, please. Now, we will go to the first part of our presentation. First is professional misconduct and second one is the professional negligence. Now, what is mean by misconduct is the conduct of a medical practitioner during the practice of his profession which would be reasonably regarded as disgraceful or dishonorable by his professional colleagues of good repute and good competence. Means any medical practitioner or a doctor does anything regarding his profession because of which his colleagues feels shameful about him or which colleagues which are having good reputation. Next slide, please. Now, what are the examples of professional misconduct? There is no specific listing about professional misconduct. I am quoting only few examples. Next slide, please. Now, first and best example of professional misconduct is doctrine res ipsa loquitur. What does it mean? The facts speak for themselves. Means, for example, I will give you a famous example. If a patient has undergone abdominal surgery and doctor by mistake kept a Caesar or any instrument or a swab in the abdomen and patient subsequently died due to that any foreign object remaining in his abdomen. That is, facts speak for themselves. In such condition, doctor don't have to defend himself because the fact itself speaks the truth. Another example, if a patient is admitted for tubectomy and doctor has operated for a hysterectomy or for any other operation, is doctrine res ipsa loquitur, and this is the criminal negligence. Next. Now, before this lecture, Tembhurnikar sir and Patkar sir have quoted about so many regulations, just like Biomedical Waste Act, Bombay Nursing Home Act, and other MTP Act. There are so many acts and there are so many laws regarding medical practice. Any registered medical practitioner violates these regulations or worse beyond these laws is violation of these regulations and considered under misconduct. Next. Very important. Not maintaining medical records. A doctor have to maintain each and every his OPD record, IPD record, and medical legal case record. And any relative or patient himself asks for medical records and comes to his OPD or hospital, he have to furnish all his medical records within 72 hours. If he is unable to furnish the medical record, he can be punished or a case can be filed against him for not maintaining medical record or for negligence. Okay? For example, in case of OPD records, medical records should be maintained up to 3 to 5 years. For IPD, it maintained up to 5 to 20 years, or up to in certain books it is 20 years. And for medical legal case records should be maintained for lifetime till the doctor is practicing. Next, please. Now, not displaying the registration. Whatever doctor writes, ask for investigation, ask for any medication, ask for any patya, he should display his registration number on his prescription. Not displaying his registration number, what he is belonging actually, is a misconduct. Okay, next. Now see, there is a picture where a doctor is showing to his patient that I have displayed my fees and all these things and my registration number is this. So doctor should ideally display his registration number. If he does not do like this, he can be punished under misconduct. Next please. Adultery or improper conduct. Now this is a very important. What do you mean by adultery or improper conduct? It's related with the character of a doctor, either a female doctor or a male doctor. What we see in the society, doctor is considered as an esteemed position in our society. So by using his esteemed position, he should not form any physical relation with either with the patient or his staff. This is applicable for male doctor and female doctor. So adultery or improper conduct or not maintaining proper character of the doctor can be punished under misconduct. Next please. Next please. Okay. Now see, there is previous slide. The lady patient asking to the doctor, I am only comfortable if there is some lady attendant with me. So maintaining or keeping a lady attendant for examining a lady's patient or a female patient is a compulsory. Okay. Next please. Next please. There is another example. Staff from a nursing home telling the doctor, keep away from myself. I am your staff. Okay. So this picture is self-explanatory. Next. Next please. Previous. Next please. In this picture, the doctor is asking to a relative of a patient to come in a private room. So doing such a thing, or these are known as not maintaining character of the doctor, or also known as adultery. Next please. Conviction of court of law for offences involving moral turpitude. If a doctor is punished for offences of moral turpitude, just like rape or abortion or other acts which may not be related with medical practice also, he may be punished under professional misconduct. Next please. Now, doctor, it's when one doctor is smoking or doing some doing or smoking a drug, nicotine or caffeine, anything in his OPD. This can be termed under misconduct. Next. Now, this doctor is saying to his patient, this is a government hospital. You better you admit in my own hospital, private hospital. Okay, you will get there a better service. So this is also a misconduct.
Excuse me, sir.
Yes.
Your voice is breaking. Can you please switch off your video?
Okay. Am I audible now?
Yes, sir. Yes, sir. Please continue.
Oh, okay. Next slide, please. Now, a patient's relative is begging in front of doctor who is on duty to please look after his patient. So, not doing so or doing like this is a misconduct. Okay. Next, the doctor is sleeping in his own OPD when he is on duty. Next, please. Now, very important. Next slide, please. Next slide, please. Now, doing a sex determination text. Tembhurnikar sir also explained about this testing for determination of sex, which is developing in a womb of a mother, is definitely a misconduct and is considered as a grievous offense in India and many countries across the world. So, doing sex determination is a misconduct. Next, please. Next, please. Next slide, please. Gadekar sir. Yes, this is a same picture. Doctor is telling to that patient that you are having almost 3 to 3. This is unethical, or this can be considered as a misconduct. Next, please. Next, please. Doctor is rightly informing to the patient that you are pregnant and pregnant is not a disease. Next, please. Issuing false certificate. So I have seen many doctors coming or fall in a problem because of issuing false certificates. So doctor should not or never issue a false certificate than any illness certificate, sickness certificate, or disability certificate, death certificate. So doctor should never issue a false certificate. Even a small or in a least a small false certificate can lead into a problem for you. Next, please. Contravening the provisions of the Drugs Act. What is mean contravening the provision of Drugs Act or Drug and Cosmetic Act? The care should be specially taken when doctors are prescribing drugs are psychotropic drugs or poisonous drugs. That these drugs are only and only should be prescribed whenever there is an absolute indication, and if you are a qualified doctor to prescribe these drugs. For example, any drug just like morphine, if you cannot prescribe to a routine patient, so contravening provisions of the Drug Act is a professional misconduct. Next, please. Association with unqualified person. Now you come across so many nursing homes or so many hospitals where so many unqualified persons or unqualified staffs are recruited, telling them as a staff nurse, telling them as a OT attendant, telling them as a brother or sister. So staff recruited in your hospital or staff working at your hospital should have a reasonable training or degree. Appointing an unqualified staff is a definitely misconduct. Next, please. Advertising. Affixing a signboard on a chemist. Doctor can advertise, cannot irrationally advertise for himself in a in a newspaper, in a radio, in a TV, or affixing a signboard. on a chemist shop or in a place where he does not reside, जहाँ पर वो काम नहीं करता है वहां पर वो एडवर्टाइज नहीं कर सकता. एडवर्टाइजिंग कैन आल्सो बी डन ओनली displaying his name, his degree and facilities afforded by him or facilities afforded at his hospital only. So advertising can be limited up to this level only. So beyond this, advertising can be considered as a misconduct, or advertising for the diseases which should not be advertised. For example, sex linked diseases or sexual problems should not be advertised. Next please. Disclosing secrets of the patients whenever not indicated. If a doctor disclose the secrets of the patients when not indicated, there is a term in forensic science, it is termed as privileged communication. So doctor can display or doctor can disclose the secrets of the patient in court of law. Doctor can disclose secrets of the patient. There is a in benefit of a layman, just like a truck driver or a train driver is a color blind, then doctor can disclose this secret. But whenever there is not indication, doctor should not disclose his secrets to the patient or relative. For example, a doctor can disclose the secret that patient is a COVID positive because it is in the benefit of the society. But please. Refusing professional service on religious grounds. A doctor should not refuse professional service on religion. Whether a doctor is or belongs to any religion, he should not refuse a service on religious. धर्म के बेसिस पे कोई सर्विस आप डिनाई नहीं कर सकते. For example, there is a emergency operation or emergency abortion, or whenever there is commonly this issue occurs in case of pubectomy or vasectomy, a doctor should not refuse his professional service on religious. If a doctor feels competent to do a vasectomy, he can do, but he is competent, but he cannot deny on religious grounds. Next please. Not obtaining consent. Doctor should always obtain surgery, or he is going for any intervention. For example, he is doing a surgery for hernia, or he is doing examination of private parts of a female patient. He should always have a consent for his. If he is going for a surgery, he should always have a written informed consent, clearly mentioning benefits and loss or surgery. He should clearly, and what are the other ways to treat this disease, it should be clearly mentioned. Next please. If patient is unconscious or patient is minor, then the consent should be taken with the guardian. Okay, not taking written informed consent before operation is a misconduct. Next please. Publishing photographs identity without patient's permission. Now you come across so many newspaper ads, you may come across so many WhatsApp status in which identity of the patient is not hidden. So doing such things is a misconduct. You cannot display or cannot publish identity of a patient which you have treated. If you want to display identity of the patient, you should take a written informed consent from the patient that I want to publish this a paper or article or your photograph as a success story of my treatment. Okay, so doctor should not publish photographs or identity of patient's permission without consent, and if he do so, it is a misconduct. Next please. Using touts or agents for procuring patients. Now this is a bitter truth of medical practice. So many patients or so many doctors assign touts or agents, or so called as a representative, to hire patients from other practitioners. So maintaining touts or agents, or in other words dichotomy, or it is also known as cut practice, or taking commission or giving commission is a misconduct. Next please. See, one agent is standing outside ICU and telling his doctor, "You haven't paid my commission." So doing this is the misconduct. Next, please. It is unethical also and misconduct also. Claiming, this is very important. Claiming to be a specialist without having special qualification. Doctor should which degree he have. For example, a gynecologist completed his MD or MS from a college and register under the council should claim as that he or she is a specialist gynecologist. But a doctor completed some certificate course in gynecology or certificate course in child health should not claim to be a pediatrician or should not claim to be a gynecologist. Doing this is a misconduct. You come across so many visiting boards of the doctors claiming to be a pediatrician or claiming to be a gynecologist. Now next is artificial insemination or in vitro fertilization without informed consent of the patient and in vitro fertilization. IVF is the biggest money market or business market in medical industry. Without informed consent of the patient and her spouse, either male or female, both. This is applied for the both side. Not doing so is a misconduct. So IVF or in artificial insemination should be done only and only after consent of both spouse and patient herself. Next, please. Now research without ethical consideration. Now there are tremendous MD degrees and PhD degrees going all over the India or all over the globe. So research doing without ethical considerations. So ethics is very important while undergoing in the research. You should obtain a institutional ethics committee permission to undergo that research. Next, please. Now, unauthorized absence for more than 2 times. If a doctor working in a government hospital or any academician or any lecturer or professor working in a college or hospital, and it is came to the notice from his superintendent or any Jilla Panchayat officer that he is unauthorized absence for more than 2 times at his duty hours without informing to his colleagues or without informing to his senior ones, it is considered as misconduct, and this is liable for penal erasure. He can be punished for some time or he can be punished for lifetime also. Next, please. Criminal abortion. Now there is a fact in India known as Medical Termination of Pregnancy Act in 1971. So doing a criminal abortion or violating Medical Termination of Pregnancy Act is professional misconduct. Okay. Next, please. Next, please. Now this is a ethical practice. What doctor is saying to the patient, you are having 30 weeks pregnancy and nothing to worry about your health, and I cannot advise you abortion. This is following MTT Act. Okay. Next. Now next, attending a patient who is under the care of another practitioner. Now this law or this law is not applicable in emergency. You can attend any patient in case of emergency or if there is any life threatening condition. But if there is no life threatening condition, there is no emergency, then you should not attend a patient of another practitioner. Okay. Next, unless and until patient wants. If patient requests you, he want to change the physician, you can consult him. Now, avoiding consultation. A patient who is a regular patient of yours comes to your OPD or comes to your hospital, you should not avoid consultation. It is your legal duty to attend him or not to avoid consultation. If you avoid the consultation, then you are doing a misconduct. Next, please. See, example is doctor is having alcohol in his OPD and telling patients wait for some time. I cannot examine you now. Doing like this is a misconduct. Next, please. A doctor is smoking his own OPD and telling the patients, I cannot examine, I am exhausted and cannot examine no more any more patients. Doing like this is the misconduct. Next, please. Running an open shop. My previous lecture also explained about this. A doctor should not run a chemist shop or a pharmacy shop, or should not run and open or shop, or could not compel patients to procure medicine from the pharmacy. He is advised. So running and opening shop for a doctor is a misconduct. Next, please. Improper association with drug manufacturing firms. Now you come across so many doctors who are having association with large pharma companies. So having association or improper association with drug manufacturing firms is a misconduct. For example, having commission or giving commission or having cut or having or enjoying or trips on the basis of pharma companies is a crime, or it is a misconduct. Next, please. Receiving and giving commission. Receiving commission for referring patient, or giving permission for being referred patient. So this is the misconduct. Next, please. Talking disparagingly about other colleagues. This is what I think is the most important in current scenario. Whenever a problem occurs to you, whether about misconduct or negligence, there are only your colleagues which are going to help you, or there are only your colleagues which can help you as an expert opinion. So never and never talk disparagingly about other colleagues. Not only it is unethical, it is also misconduct. So always and always try to respect your professional colleagues or professional brothers. Next, please. Now see, doctor is wondering why all the patients have gone to the another's OPD. So what should I do? So he is thinking in negative way. How can I blame another doctor, or how can I disobey another doctor? So this should not be done like this. Next. Now after we have come to end come to the end of the topic misconduct. Now we will discuss about negligence. There is a marginal difference between negligence and misconduct. Now what is negligence? It is defined as an omission to do something which a reasonable person would do, or doing something which a reasonable person would not. There are two things. There is one is act of omission and there is act of commission. मतलब जो करना चाहिए वो नहीं किया, और जो नहीं करना चाहिए वो किया. That is negligence. That is in a final line you may see, with a reasonable person would do not. What is mean by reasonable person? If a doctor come across any patient or doctor do a negligence, he is compared with a reasonable person to a class which he belongs. For example, a general practitioner is compared with a general practitioner. A cardiac surgeon is compared with a cardiac surgeon, or a cardiologist is compared with a cardiologist. A general practitioner cannot be compared with a cardiologist, or a general practitioner cannot be compared with a neurosurgeon. Understood? Next. Omission to do something, that is act of omission, which a reasonable person would do, or doing something, or that is act of commission, which a reasonable person would not do. Consequences of negligence are product liability are covered in India under Consumer Protection Act. Okay. Next, please. Next, please. Now, in which condition doctors can be sued, or doctor can come in a problem regarding negligence? First is doctor owned a patient a duty. मतलब जब डॉक्टर ड्यूटी पे था तो वही ड्यूटी पे वो जो पेशेंट के लिए असाइन था वो पेशेंट के बारे में नेग्लिजेंस हुआ है. फर्स्ट इज ड्यूटी. दीज आर फेमसली नोन एज 4D दैट ड्यूटी. मतलब डॉक्टर को वो ड्यूटी करनी चाहिए थी और उसने वो ड्यूटी तोड़ी या नहीं की. डॉक्टर्स कंडक्ट वाज द डायरेक्ट और प्रॉक्सिमेट कॉज ऑफ डॉक्टर. मतलब डॉक्टर ने जो किया है उसी की वजह से पेशेंट को डैमेज हुआ. नाउ पेशेंट सफर एक्चुअल डैमेज. लास्ट इज द पेशेंट को एक्चुअल डैमेज हुआ है. ये अगर चारों चीजें हैं तो ही और ओनली एंड ओनली देन डॉक्टर कैन कैन बी सूड फॉर अ नेग्लिजेंस। और ये चारों चीजें प्रूव करने की जिम्मेदारी होती है कंप्लेनेंट। ओके, कंप्लेनेंट हैव टू प्रूव ऑल दीज थिंग्स, ड्यूटी, डेलिरेक्ट, डायरेक्ट, प्रीवियस वन, डेलिरेक्ट और डायरेक्ट और actual damage or direct or proximate cause of damage. Next. Now there are two types of negligence. One is civil negligence and second is the criminal negligence. There is a simple hairline change between civil negligence or criminal negligence, or there is no clear-cut bifurcation of civil negligence or criminal negligence. We will discuss what is it. Now, any negligence is first is anything which causes physical, mental, or financial harm to the patient. Either it is due to physical harm, or financial harm, or mental harm related with the psychology is a negligence. The patient or his relatives take the case of professional negligence to civil court, demanding compensation. अगर patient के relative compensation मांगने के लिए court चले गए, it comes under civil negligence. Now, in criminal negligence, if a patient's relative or a patient himself go to the criminal court to sue a doctor or to punish a doctor is a criminal negligence. Now, first a few examples of civil negligence. Failure to regard contractual obligations. मतलब a doctor is compelled to do or compelled to treat patient unless he wants or unless he feel competent. जब तक डॉक्टर को लगता है मैं पेशेंट को ट्रीट कर पाऊंगा या जब तक पेशेंट चाहता है तब तक डॉक्टर को उसको अपनी सर्विस देनी चाहिए. Second is investigation. Doctor should do investigation whenever required. Doctor should do proper efforts to diagnose a patient. Means what is diagnosis? It is never expected from a law that diagnosis should be clear cut, but diagnosis should be relevant. For example, a patient suffering from loose motion, there may be diagnosis either as amoebic dysentery or cholera or bacterial dysentery. But if a patient is suffering from a diarrhea, doctor should not diagnose as a fracture of humerus. Diagnosing in such a different way is a negligence. Now next is treatment. Treatment should be reasonable one on basis on common sense. Operations. Next is operations whenever there is indicated. Issuing wrong certificates and reports. This is also negligence. Next one. Next one. Now criminal negligence. Now criminal negligence is there is gross carelessness or gross negligent activity or act of a doctor causes serious irreparable bodily harm or death of the patient. इतना हार्म होना कि वो रिपेयर ही ना हो सके या इतना हार्म होना कि पेशेंट की डेथ हो जाए. नाउ इसके बहुत सारे एग्जांपल मैं वन बाय वन बताऊंगा. द पेशेंट और रिलेटिव गो टू द क्रिमिनल कोर्ट. द व्हाट इज द डिमांड? डिमांड इज टू पनिश द डॉक्टर. ओके, नेक्स्ट. Now there are famous examples. First is next slide. Next, please. Criminal abortion. Doing a criminal abortion is a negligence. Next. Now, what is difference between criminal abortion as a misconduct and criminal abortion as a negligence? Now, criminal abortion as a misconduct is doctor is intentionally doing criminal abortion. On criminal abortion as a negligence, doctor unknowingly doing a criminal abortion, not knowing the pregnancies of a 30 weeks, not knowing pregnancy of 34 is a negligence. Now, lack of care during selection of the patient, lack of care during diagnosing the patient, lack of care during investigating the patient, or lack of care during operation of the patient. Now, what is the lack of care during selection? How a doctor can lack during selection of patient? For example, a general practitioner should not come across or should not take a patient in having a myocardial infarction or having a serious injury. He should refer after a primary treatment. Next, please. Lack of care during. Next. Next, please. Examining the patient, investigating the patient, diagnosing the patient, and treating the patient. So, doctor should have a reasonable care. He should take a reasonable care while examining, investigating, diagnosing, and treating. Now, there should not be over investigation or there should not be less investigation. For example, a patient is having abdominal pain, he should be investigated for sonography if it is indicated. It should not be randomly investigated for MRI or other future steps. Diagnosing the patient. Now, what is I have given example of dysentery. So, doctor should take reasonable care. Either from differential diagnosis, he should diagnose the patient. Treating the patient. For example, a patient is suffering from dehydration. Doctor should give at least a fluid support or fluid maintaining therapy. That is not giving a fluid in a patient of patient. Now, what is the operation? If a patient is having fracture of right hand and doctor have applied a splint or doctor have applied a plaster for a left hand or applied a too tight plaster, is a negligence. Okay. Operation without consent, I have discussed about it. Not doing operation in time, though the patient has given the consent. Patient ने consent दिया है, तो भी उसने operation वो time में नहीं किया. It is a not doing operation in a time. Operation causing mutilation means a patient comes to you and you have operated the patient, and due to your operation or due to your treatment, there is a harm to the patient. So that is a negligence. Operation interfering with intellectual capacity, operation interfering with the hearing capacity, operation interfering with the vision capacity, or operation interfering with the reproductive capacity, or harming all these capacities or harming by any means of one of these. Now, death during operation, operation on wrong side, and what I have discussed about truth speaks itself, leaving the sponges of instrument in the body during operation. Next, please. What is the criminal negligence? Doctor should do a reasonable care. Not doing a reasonable care as compared with your reasonable colleagues. For example, anesthetist is compared with the anesthetist. Not doing this is a negligence. Anesthesia in the wrong dose or wrong preparation of anesthesia or improper oxygenation during anesthesia. There is a famous case in 1971 where a patient in appendectomy died due to stoppage of oxygenation for 6 minutes, and he died after 6 months due to hypoxic brain damage, and the doctor was punished for 10 years. So improper oxygenation during anesthesia, giving a wrong blood means A positive person giving a blood of B positive, or giving wrong dose causing blindness or deafness, misfitting dentures or too tight plasters, or overexposure to radiations or overexposure to any heat. This is also a famous case. A patient had a gangrene in his leg due to occupation. This is also negligence. Next, please. Now there is a difference, civil negligence and criminal negligence. This is for academic purpose. Basically, in civil negligence, doctor is sued for a compensation, and in criminal negligence, doctor is asked for a punishment. And civil negligence in tried in a civil court, and criminal negligence is tried in a criminal court. Next, please. Next, please. Now, what is the there is another term is a contributory. And the contributory negligence is a good defense for a doctor, but in civil, what is a contributory negligence? Contributory negligence means negligence caused by a doctor is accompanied by a certain negligence by a patient or by a hospital staff. So that is a contributory negligence. So this can be a good defense for a doctor only in civil cases. But there are two exceptions for this rule. The first is last clear chance doctrine. Means contributory negligence caused by a patient, but doctor had a certain time to treat the damage due to contributory negligence, but he has failed to treat in a definite time. So he is punished under negligence. So that is known as last clear chance doctrine. Means a doctor clear cut had a chance to repair the damage. And next is avoidable consequences rule. Now, what is avoidable consequences rule? Avoidable consequences rule means negligence caused by a doctor is accompanied by negligence caused by a patient also. Okay, so that is, but if the damage caused due to a doctor's negligence, doctor cannot plead that negligence caused by a patient. Understood? If a patient is suffering from a fracture of knee and doctor has advised him to not to move his leg, but patient started moving his leg, but doctor has done a wrong surgery already, then doctor cannot have a plea about avoidable consequences. Next, please. No, next, please. Next, please. The corporate negligence is about having a big hospitals. बड़े-बड़े hospitals में ये problem होता है because of failure of those persons who are responsible for providing the accommodation and facilities. For example, hospital provide defective equipment or retains incompetent employee. For example, bed or you are having angiography unit, angioplasty unit. This is known as corporate negligence. Now, in corporate negligence, who is the head of that particular hospital can be punished. Next, please. And novus actus intervenis. Now, what is novus actus intervenis means damage caused to the patient due to intervention by a treatment. For example, patient was going normally or about to recover in a certain time, but a treatment intervened by a doctor. For example, in a patient of DVT, doctor undergone a surgery. All right, and after that surgery, patient suddenly deteriorated and died. Then it is considered as novus actus intervenis. It is considered as the damage caused to the patient is due to doctor's intervention or treatment. Next, please. Product liability. Now, what is product liability? Liability of a producer, agent, or seller of medicines, instruments, or appliances, the use of which alone has caused some damage. For example, instruments or pottery machine or other these things. This is known as product, but it is utmost duty of a doctor or superintendent to check about that quality of the products. Okay, this is the product liability. Next, vicarious responsibility. In other words, it is known as respondent superior. Means, for example, I will give an example. A patient is deteriorated during an operation due to some mistake of a assisting sister or assisting nurse or assisting brother. So doctor should not say like this, this was not my responsibility. The damage occurred to the patient is because of some mistake done by a sister. Ultimate responsibility is of a surgeon or ultimate responsibility is of a doctor to do surgery without any complications. That is known as vicarious responsibility. Okay. Now, respondent is superior. Now, this is not a vice versa. If a superior does a mistake, then inferior cannot be punished. This is only respondent superior. Next, please. Now, how can we avoid from a negligence or negligence? How we commonly come across so many cases, we commonly come across so many problems that a doctor is punished or doctor is harmed by a mob. Now, how can we avoid, or common is the reason behind the negligence? Now, communication failure. What I do always say, doctor should always and always communicate with the patient and his relatives going on, or what are the treatment options available and what the treatment we are giving and what is the effect of giving the treatment and what are the effects of not giving the treatment. Now, second is documentation improper. Doctor should always and always do proper documentation. For example, if you write tetanus injection given and if you write tetanus injection given under all aseptic precautions, if you write like this, you will not be punished. And if you write tetanus injection given, then you will be in a query whether you have done aseptic precaution or not. So documentation is very important. Wrong treatment, you should always give a reasonable treatment. Second, diagnosis error, I have explained about this. Now, delay, you should not delay in a treatment, especially in emergency cases. You should Start treatment at the right time. That is known as golden period to start the treatment. Next is failure to refer in time. Don't be afraid, or don't be consider you are a failure if you refer to another doctor. Always feel privileged to refer your patient to your another colleague or brother. Okay, next. Now, what are the IPCs regarding negligence, or what are the IPCs in which doctor can be punished under negligence? There are so many IPCs. Among 304A is a homicide, and 337 and 338, that is a simple injury and grievous injury, in which imprisonment up to 2 years and 10 years. Okay, last three are important: operation, all these things. Next, please. Now, what is told in Ayurveda, or what is told in our old Sanhitas about if doctor do negligence or misconduct? विषग मिथ्याचरण दंड्य, मतलब अगर डॉक्टर कोई मिथ्या आचरण करता है या डॉक्टर कोई गलत चीज करता है, it should be punished. He should be punished. That is a reference from Yajnavalkya Smriti, and second is from Manu or Manu Smriti. So he should be punished. Next. Now, what can be the defense, or a doctor can, how a doctor can be saved against a negligence? First, when the doctor has, he should best wait, he has no duty or he was not on duty towards the patient. Second, duty discharge according to prevailing standard. For example, whatever the duty I have given, or whatever the treatment, or whatever the diagnostic, whatever the investigation, or whatever the surgery done to the patient is according to prevailing standards of the medical science, and not done anything wrong, or if happened anything
Hello. Hello. Gajanan sir. Hello. Hello. There is some technical problem with speaker's end. So please hold on for a few minutes. We regret the inconvenience caused. Hello. Gajanan sir, please connect your audio on the mobile device. Please connect your audio.
Hello. Hello.
Yes, sir. You are audible now. Please
Please
continue.
share the screen.
It is shared, sir. Is it not visible to you?
Yes. Am I audible now?
Yes, sir. Yes, sir. Please
Ah.
continue.
Now next is therapeutic misadventure. Means therapeutic misadventure means the treatment given to the patient was a better one. That is a benefit loss ratio was given by considering benefit of the treatment. Despite of considering benefit of the treatment, harm to the patient harm occurred to the patient. That is known as therapeutic misadventure. Okay. Next is error of judgment or error of now error of judgment or error of diagnosis can happen from anybody, from either a general practitioner or a super specialty surgeon also. So error of judgment can be expected. Now contributory negligence, you can claim that the negligence caused to the patient or harm caused to the patient was not only due to the negligence caused, it is accompanied by contributory.
Hello. Gajanan sir.
Sir.
Your voice is not audible in between.
Hello.
Yes, sir.
Is it
please.
audible now?
Yes, sir. Continue, please.
Now limitation. Now next last is the limitation of the treatment. Now whatever treatment is given to you is according to the prevailing standards, but there are certain limitations to the medical treatment. It cannot go beyond the limitation of the medical science. So these are the natural or these are the prevailing limitations of the medical treatment. Now last is time limit. A case against civil negligence should be claimed before 2 years. If a patient claims a case after 2 years, you can ask to the court like this. The case is filed after the time. Next, please. Now, what a doctor can do or how doctor can be cautious for negligence. First is up-to-date knowledge. Medical science is changing day by day, hours to hours. So doctor should always update his knowledge. Next, written in whatever you do, you should do a written info. You should ask for a written informed consent from the patient. Next is documentation. I have given example about injection TT. So you should do a documentation. Investigation, not to over investigate, not to less investigate. Okay, you have to investigate the patient. Next, consult the colleague. Always and always consult a colleague. पेशेंट से हमारे कलीग से या प्रोफेशनल ब्रदर से हमेशा कंसल्ट करना है, क्योंकि इज ऑलवेज बेटर टू treat a patient in case of emergency in presence of 2 experts. Sensitivity test, though so many drugs are not sensitive to certain patients, in a sensitive drug just like cephalosporins or diclofenac, you should do sensitivity test before administering the injections. Next is don't go beyond a specialization. Very, very important. You may know a case of a surgeon who has done a cesarean section in Pune and was punished under misconduct. So surgery and gynecology are 2 different branches. You should never go beyond your special. Though you feel you are competent, you should not go beyond your expertise. Next, please. Previous one. Previous. Now give certificates with the care. Any certificate, illness, sickness, or any certificates, you should always and always give with a due care after examining the patient. and you should not give false certificates. Again, you should always keep a Xerox copy. You should always keep a carbon copy for your certificates. And next is no telephonic advice. So many patients ask you for a WhatsApp message for your medicines or WhatsApp advice. More and more, what I do advise is avoid telephonic consultation. Though patients are your near and dear ones, avoid telephonic consultations. Next. Now we have come to the end of my topic. I will end with the three famous quotes from Vedas. फर्स्ट इज अतिक्रामतो दूरिता पदानी, हमें बुरे मार्ग से हमें दूर रखिए. नेक्स्ट प्लीज. आरे श्याम दूरिता दमिक दमिक. एंड लास्ट इज अपास्मत सर्वम दुर्मतम, हमारे में से सारी दुर्मति निकाल दो. यही हम भगवान के पास या यही हम ईश्वर के पास प्रार्थना करते हैं. नेक्स्ट वन. थैंक यू सो मच फॉर योर पेशेंट हियरिंग and thank you so much, and your questions and suggestions are most welcome. Thank you very much. Thank you whole the team, Dhanvantari Ayurved Medical College, Udgir, and I also thank my principal, Government Ayurved College, Vadodara, my HOD, Department of Agadtantra, Government Ayurved College, Vadodara. Over to you, Pankaj.
Thank you, sir. It is a nice lecture. Thank you, sir, for explaining this complicated subject in such a simple way.
Pleasure.
Sir, there is one question. May I ask?
Yes, sure.
If one has completed BMH degree or has a registered certificate in a Maharashtra state and want to do practice in other state,
Yes.
what are the guidelines to be followed?
If a person has any, not only Maharashtra, if he is registered or she is registered in the concerned, he have to re-register herself or himself in the concerned state, have to cancel her own registration from state which he belong, and can practice in that state also, according to the guidelines and laws in that particular state. For example, I was registered under Maharashtra Council of Indian Medicine. For to be practiced in Gujarat, I have cancelled my registration from Maharashtra and registered myself in Gujarat Council of Indian Medicine. Understood? So always and always better to register yourself in the concerned state.
Thank you, sir.
And practice according to laws of that particular state. If in Maharashtra you can do so many surgeries, but this is not applicable for Gujarat.
Okay, sir. Thank you, sir. Now I request Dr. Sangita Deshmukh Madam to share keynote address for this session. Dr. Sangita Deshmukh Madam.
Am I audible, sir?
Yes,
madam. Yes, madam.
Good afternoon to all. It is my pleasure to attend the session as a chairperson. I congratulate Dr. Gajanan Chatuphale, sir, for delivering knowledgeable lecture with well-organized content. All the points of subject were effectively presented. The lecture was highly beneficial and informative for all the doctors. The topic for the session was well chosen. As we know, in day-to-day life, while practicing, we should be aware and alert in order to prevent professional misconduct and professional negligence. I would like to highlight some points on the same topic, and we are discussing the topic professional misconduct. It is also known as infamous conduct or the ethical negligence. Huge list have been explained by the Gajanan sir, but all the misconduct examples are listed in 6 A's only. To avoid the professional misconduct, we must remember only 6 A's. 6 A's: 1. Adultery, abortion, alcohol, addiction, association with unqualified persons, and last one is advertising. All explanation sir had given. One more thing I would to share professional misconduct by doctor is governed by Indian Medical Council. Professional conduct, etiquettes and ethics regulation 2002, under 2002, which is made by under Medical Council IMC Act 1956. These acts have two chapters, chapter number 6 and chapter number 7. Chapter number 6 unethical acts and chapter number 7 is leading with misconducts. Okay. What is the action of this regulation 2002? The appropriate medical council would hold inquiry and give opportunity to the registered medical practitioner to be heard. A complaint should be decided within a period of 6 months. And if found guilty, it may award punishment. What is the punishment? First of all, warning notice. A written notice is issued for not to repeat his conduct. And then eraser of name from the medical register. Eraser should be temporary or the permanent. Temporary eraser means suspension for few duration, and permanent, that is called professional death sentence. PDS, that is for the rest of life. Then all the points should covered, all are covered by Dr. Gajanan Chatuphale sir. Well, at the end, I would like to thank Principal Dr. Datta Patil sir, Dr. Bhangya sir, and Dr. Gadekar sir, and all the entire team putting their efforts for organizing this webinar. It was a nice experience connecting with all of you. Thank you.
Thank you, madam, for such an informative speech, and thank you for your time. We are honored to have you, madam. Now, I request Dr. Charandas Gadekar sir for a vote of thanks.
Thank you, Dr. Thanks. Good afternoon, everyone. I am Dr. Charandas Gadekar, Assistant Professor, Agadtantra Department.
Thank you, Dr. Bhangya sir. Good afternoon, everyone. I am Dr. Charandas Govindrao Gadekar, Assistant Professor, Agadtantra Department, Dhanvantari Ayurved Mahavidyalaya and Hospital. I am here to present vote of thanks. I would like to thank our inaugural guest, Honorable Dr. Charandas, for inauguration of our national webinar. I would like to thank our chairperson, Honorable Dr. Abhay Patkar and Dr. Sangita for joining us with their knowledge. I would like to thank our guest speakers, Honorable Dr. Vinayak Tembhurnikar sir and Honorable Dr. Gajanan Chatuphale sir for giving their valuable insights. I would like to thank our principal, Honorable Dr. Dattatreya Patil sir, for giving permission to organize their national webinar. I would also like to thank our academic coordinator, Honorable Dr. Avinash Jadhav sir. Also, I thank to all participants, UG, PG students, teaching staff, medical officers, and practitioners. Thank you so much.
Feedback link has been shared in the YouTube chat box. Please fill the feedback so that e-certificates can be generated. E-certificates will be sent from webinar@damchudgir.edu.in email ID. Please check your inbox or your spam folder for getting this certificate in the PDF format. Certificate will be issued on 12th of the April. Please listen carefully, that certificate will be issued on 12th of April. There are so many participants and there are some limits on the daily mail numbers. So we have to send the certificates in batches. So please cooperate with us. We will be sending your certificates to everyone. Thank you for joining us. The next webinar's details will be shared on the Telegram groups as well as on the WhatsApp groups. Please subscribe to our YouTube channel so that you can get all the notifications for the further webinars. Thank you, all of you, for joining us.